So essentially what you were doing for your client was covering up the subject matter of the clerk advice, weren't you?
I don't think that's a fair characterisation of it. I think there is a question to be asked about the original decision back in, I guess, mid-2013, following the clerk advice and the disclosure of the Helen Rose report by the criminal lawyers, as to why they redacted Gareth Jenkins' name and why they didn't call out at that point the connection. At this stage, I'm looking to pass on the advice from the criminal lawyers, which is their decision. They've made those choices. I'm not a criminal lawyer. And I'm looking at it also from the perspective of the scheme. As I say, from a scheme perspective, it's a different question.
I don't want to repeat myself, Mr. Parsons, but this is you advising your client. This isn't a Cartwright King letter, it's your letter, isn't it?
It is, but I think it's clear from the email sent below that I'd spoken to Cartwright King. It reflected a combined approach, and they're all copied on the email.
We're now in 2024. It's right, isn't it, Mr. Parsons, that if you hadn't advised Post Office to downplay, minimise or ignore the Gareth Jenkins issue in June 2014, the last 10 years of the lives of hundreds of sub-postmasters who've been convicted, bankrupted, lost their reputations would have been very different. Do you see that?
I do see that, but as I say, I think that goes back to the original problem back in 2013 and the decisions Post Office made around their criminal disclosures at that point in time.
I want to move on to another topic, which is the conduct of the mediation scheme. I'm just going to take you to, I'm going to refer you to a couple of statements you've made in your witness statement. We don't need to turn them up. Paragraph 149.2 of your statement, you say, if a case went to mediation, a lawyer from WBD would attend in person to represent Poll. I recall attending 2 or 3 mediations personally, but generally this was done by members of the WBD team who I supervised. That's right, isn't it?
Sorry, could you give me the reference again? It hasn't come up.
Yes, it's paragraph 149.2.
I think, Mr. Parsons, Mr. Jacobs was hoping to do this without getting it up on the screen, but you want it on the screen so that you can see it.
I've got a hard copy.
You have a hard copy.
Got a hard copy, all right.
That might save time. So you've got that, haven't you?
Yes.
And then if we get, I'll just read out paragraph 253.3 of your statement. That might involve a bit of rapid page turning on your part. I'll read it out while you're doing that. You say, I was not of the view that Poll were refusing to engage properly in the mediation process. Now, my question to you is, you must have been aware, Mr. Parsons, that in practice, the Post Office approach to mediations was disingenuous and amounted to a sham. Post Office were not mediating in good faith, were they?
I don't accept that.
Okay. Well, I'll develop my questions to you. Because we've spoken to many of our clients, and let me tell you what one of our clients, Peter Holloway, has told us what happened to him. He says he spent a lot of work preparing for the mediation, turned up, presented what he wanted to say, produced lots of documents in support of his arguments, and then everybody went away. And a mediator came back to see him at about 3 o'clock in the afternoon, looking tired. Mr. Holloway says haggard, and the mediator apologized to him, and he said Post Office are refusing to make any offer. He couldn't quite believe it. He said that the Post Office representatives had been sent to the mediation with express instructions not to settle at all. And this isn't just Mr. Holloway telling us this. We've spoken to at least a dozen other clients who attended mediations, and they all say that Post Office sent representatives, Bond Dickinson were there, to mediations with no authority or instructions to settle. That's what was going on, isn't it?
So each case was assessed on its own merits. Some of those cases we advised Post Office to settle, some of them we advised Post Office not to settle. There was then a discussion internally about whether Post Office should still attend mediations where it had no mandate to settle. And the view taken was that it was appropriate still to attend those mediations so that the issues between the parties could be discussed. I can understand why that would have been frustrating for some of your clients, but it was a decision taken in good faith at the time.
Well, there were offers made in some cases, but our instructions from our clients are the offers were always derisory, and we've heard Paula Venables talk about token offers, and they were made on the basis that the sub-postmaster agreed not to bring any action in the future against the post office. So essentially, what post office were doing in the few cases where they made offers which were derisory was they were using the mediations to strengthen the position of post office against future claims, weren't they?
I think it's fairly ordinary for two parties at a mediation who reach an arrangement to enter into a settlement agreement of future claims.
But making very derisory offers that didn't represent the sort of claims that were made in the group litigation.
I think two parties to a mediation will always have different views as to the value of offers put. As I said, Post Office went into those mediations in good faith, having considered every case. That was my understanding.
Well, it's not good faith, is it, Mr. Parsons, to send representatives into a mediation with instructions to make no offer and not to settle?
Well, I hope I explained that just a minute ago, that the intention, I accept that some mediations were conducted on the basis that there was no mandate to settle, but the intention was to go and hopefully explain Post Office's position, and it was thought there was still value in having that conversation.
Can I put to you an explanation of Post Office's position in the mediations that has already been received and evidenced by the inquiry? And it comes from Alan Bates, and in his witness statement at paragraph 157, and we don't need to put it up on the screen, but the reference is WITN 000500100. What Mr. Bates says is, I believe the mediation scheme failed as it was part of a cover-up by Poll. I expect Poll discovered things they did not like and did not want to come out. There was definitely an element of not wanting to accept fault. I believe Poll had no intention whatsoever of getting to a mutually acceptable and fair decision. If anything, it seemed as if Poll had been using the scheme as a fishing expedition to see what evidence sub-postmasters actually had about Horizon. And my question for you, Mr. Parsons, is that Alan Bates is right, isn't he? You supervised this, you were using the mediation scheme in an adversarial way in order to obtain some sort of tactical advantage against the sub-postmasters.
I don't recognise that description of the mediation scheme. My understanding is Post Office went into it in good faith with an intention to reinvestigate the 150 cases, and where those cases showed errors on Post Office's part, it was willing to settle.
My final questions for you. In your witness statement, you haven't made any apology or statement of regret for your actions. And many of our clients have been aghast at the content of the evidence that you've given, the emails that Mr. Blake took you to yesterday. Sally Stringer is one of our clients, and she emailed Mr. Enright, who sits next to me, at 10:20 this morning. And what she says is, of you and your evidence, his evidence is the absolute epitome of arrogance, deceit, corporate corruption, and is an absolute disgrace. I suppose you might think that's quite strong language, Mr. Parsons.
I have apologised within my statement, and to make it clear, I'll apologise again now. During my time acting for Post Office, we made some mistakes along the way. I apologised for them at the time, and I apologise to your clients for them now.